Today we're going to be talking about disclosures. So normally when I talk about disclosures, I will talk about a specific form and I'll go over that form in detail. But today we're going to do more of a broad overview of disclosures in general. I had the privilege of attending a presentation given by a CAR attorney or legal counsel, or I'm not sure their exact title, but it was really interesting. And I have a copy of their slideshow. So we won't be going over every single slide. Their presentation was 3 hours. We obviously don't have 3 hours here. Depending on how much we get through, I may or may not pick it up next month, because the first workshop of the month is usually contract related. So we'll see how we go. If you guys have questions as we go along, let me know. When I share my screen, I lose the ability to see you guys sometimes. So go ahead and just peep up if you have a question. Okay. Can you guys see my screen okay? Okay, great. So one of the things about disclosures is obviously California has a ton of disclosures. Some of them we use in the transactions, some of them we don't use. Some of them are, transaction specific, like if a certain thing happens, then we'll use this disclosure or advisory, and otherwise we won't. The purpose of disclosures really is to limit our liability, limit the seller's liability, because the number one reason that people end up in court when a transaction goes bad usually has to do with disclosures. There used to be an old rule, kind of buyer beware, and that went away. And now it's definitely sellers are required to disclose material facts affecting the value or desirability of the property. And so that's a phrase you want to, kind of keep in mind. And actually, when in doubt, you should disclose. So if you're questioning, or your seller's questioning, should I disclose this? Just the fact that they're questioning it, usually the answer would be yes, they should disclose it. Sellers have a lot more power when they're disclosing while in a transaction, because buyers are generally excited and they still want to buy it, and they're willing to accept something that if they find out after they close, then at that point they might not be willing to accept it. So one of the disclosures that the state of California feels is actually the most important is the agency. So there's a couple ways that agency is disclosed. One is there's an AD form, and you'll see that this AD form is automatically connected to whenever you fill out like the purchase agreement or the buyer representation agreement or the seller's listing agreement. This is going to be the very first form that comes up, and there's a couple of different forms that automatically get attached to those agreements, and this will be the very first one. It's in the first position on purpose. It has to be the first form that they sign, and failure to have them sign this form can make the listing be unenforceable. So you can actually lose the listing if you don't have them sign this form first. You can actually do the entire transaction and end up not getting paid. It's a DRE violation. And there was this case, I'm not sure how you pronounce these names, but it was, in this specific case, it was a dual agency. So the seller was also representing the buyer. The seller had the seller's agent had the seller sign the listing agreement, but not sign the AD form. And when they went under contract, they had the seller sign it then, but the seller changed their mind after they went under contract, and the seller did not have to sell, because not only do you have to have them sign this form, but you have to have them sign it before they sign the listing agreement. So timing is also very important on when they sign this. And so you can see here, there's an actual form, the AD form, and then there is also on the RPA itself, there's an agency section. And a lot of times when we're reviewing contracts, we will see that agents forget to mark one of these boxes. Very important that these boxes get marked, even if it seems like everybody in the transaction already knows who's representing the buyer and who's representing the seller. You still have to mark these boxes and have it disclosed. One of the ways that you'll know whether it's a dual agency, so dual agency is not done at the agent level, it's actually done at the broker level. So if your broker has the same number as the broker on the other side of the transaction, then that is considered a dual agency transaction. So in my town or my community, we have a Keller Williams in Visalia. We also have one in Kings County, which is the county next to us, but it's the same, it's owned by the same broker. And so in that case, if I was an agent in Visalia, there's an agent in Hanford, we would be considered dual agency. But if it was a Keller Williams office in the next county up, say Fresno, we would not be dual agency because we have different brokers, even though we're both Keller Williams. So agency is very important. One of the things that the form discusses is the fact that in a dual agency transaction, there's some information that still has to remain confidential. So obviously when you're representing the buyer, you're working for their best interest, and when you're representing the seller, you're working for their best interest. But you can't give away things that would weaken one particular party's position. So like if they're moving because they're having a job transfer and they've got to get it sold by a certain date, like you can't disclose that to the other party without the seller's or the buyer's permission, depending on which party it is. So just be wary of that if you are in a dual agency position. And again, dual agency doesn't have to be at the agent's level, it can be at the broker's level. The next form that you're going to see that's automatically attached is the PRBS, which is the possible representation of more than one buyer or seller. And what this does is this informs the party that they might be competing against someone in the same office. So as a Keller Williams agent, if I'm submitting an offer on this house, there might be another Keller Williams agent in my office who's also submitting an offer on the same house. So it kind of explains that. And this also has to be done no later than when the offer is made. And so CAR has made that really easy for us in that they have attached that to the RPA. So it's automatically on there. The RPA itself, there's a box that's selected and it's automatically selected. You cannot unselect it. And this is where each party acknowledges that they have received that form. And then there's the transfer disclosure statement. And so the transfer disclosure statement requires the seller to answer very specific questions about the house. One thing that I didn't know in the beginning is there's these three boxes here right at the very top of the form. So right up here, they get missed a lot. And I never quite knew which box to check, but the majority of the times we're going to select the no substituted disclosures for this transfer. And like I said, that gets missed a lot by sellers. So we want to make sure, and we might even need to advise our sellers, as to what box to check. And then the TDS has, did someone say something?
Yeah, no, so I had a question on that. So if those other two boxes on the top, is that if you like had a termite inspection or something like that you'd already had done on the property, you can mark those?
I've never quite understood this part, because even if you've had, it comes to disclosures, so you can have the report, but I think what they're saying is if you're using a different type of disclosure than the transfer disclosure statement. Like, I'm not 100% sure. That's why it's never really made a whole bunch of
Well,
sense to
yeah,
me.
but it says reports or disclosures, so that's, yeah. I mean, I would say like, or if there was an easement or something like that, that you more have to mark that box.
Well,
As,
because with the easement, you would still get that. I mean, you could still disclose that on this form, and it would come as part of the title report. So,
so you're just kind of doubling down if you do check it.
yeah,
Okay.
yeah.
All right.
But they said that the majority of the time, this no substituted disclosure for this transfer form would be the one that gets checked.
Okay.
And then another question we get sometimes, so this is where the seller is going to mark what is part of the property. And so let's say we have a microwave that may or may not transfer with the property. Maybe the seller is going to take the microwave with them when they go. So then do they mark that it has a microwave? The answer is yes. So you're going to mark anything on here that the home has, but this is not part of the RPA. It's just a disclosure. So on the RPA, on the purchase agreement, that's where you would identify what's staying or what's leaving within the house. One of the things that we may talk about later on is the water conserving plumbing fixtures, and it references back to this. So I'm just going to go ahead and mention it now. So there is a place to mark whether there's water conserving plumbing fixtures. If your client doesn't know whether the fixtures they have are water conserving or not, they would just leave that blank because, obviously it's going to have plumbing fixtures, but who knows whether they're water conserving or not. So that would just get left blank in that situation. The other thing about the transfer disclosure statement is that it has very specific language on these questions. So it says, are you the seller aware of the following? So if your seller is not aware, then they would mark it no. And sometimes, we want to guess, well, I think maybe, but I'm not sure. The answer would be no, they're not aware. But there is an explanation mark box. So they could mark it no and then say, I'm not sure whether it's this or that. And anytime that your seller marks a box yes, you want to make sure that they also put an explanation in the explanation box. Now, it's really important that this form gets filled out completely. So if you're representing the seller and you get the form, take a look at it. And if there's anything that got missed, go ahead and send it back to them and have them complete it. Same thing if you're representing the buyer. If you get it and it's got stuff that's missing, not completely filled out, send it back to the seller and have them get it complete before you give it to your buyer. Michelle, I see your hands up.
Yeah, just real quick on the water fixtures. Let's just say there's one item that has the water fixtures saving water, but nothing else in the house does. If it's even one, that's a yes, right? You mark it, even if it's one item.
What I would do there is put a little explanation underneath because that could be interpreted both ways. Somebody might read that and say, oh, okay, the whole house has water conserving plumbing fixtures. And we don't want them to assume that if that's not the case. But they could, like the seller, like you're saying, answer it, well, it has one, so it does have water conserving plumbing fixtures. So I would just make a note of it so that it
Yes,
just
but not all.
explains it. Yeah, exactly. And you can just write it right off to the side. I mean, it's just information that's being conveyed from seller to buyer.
Thank you.
Sometimes a seller will need help with this form. As agents, under no circumstances are we allowed to help them fill this out. If they need help filling it out, you're going to want to refer them to a family member or somebody else that can help them. But as agents, we don't want to take on that liability because if something comes up, it would be easy for the seller to say, well, I told her no, but she marked that box anyways, and I didn't know it. So we just don't take that liability at all. And part of this form or all disclosures is we want to document everything in writing so that we have a history in case we need that, in case something comes up, we can say, okay, it was done, in writing. There is another form, and interesting enough, I had never heard of this form before going to the workshop, and it's called the DIA. It's a Disclosure Information Advisory Form, and you can give that to the seller, and it kind of, or it gives direction on to the seller on how to fill out the forms. And so verbally, I always tell my sellers, okay, this is what you want to do. And I'm pointing out some of the things that I'm pointing out here. But that disclosure advisory is also a good form to give to them. They called it a risk management form. So the other thing on it, let me see if it comes down here. It doesn't. Okay. The other thing on it, and we'll be talking about the AVID in a little bit. No, that's the next form. So forget that. Okay. So let's see here. The seller is required to fill out the form even if they have no knowledge. It must be fully completed. Seller should elaborate on yes answers. So that's where I was saying anytime they mark yes, there's a place to put an explanation, and you want to make sure that they've done that. And it is required by law for them to fill out this form. This is the disclosure information advisory form that I was talking about, what they referred to as a risk management form. And what some of the things that it points out is that they want to avoid words such as small or minor. Basically, you want to avoid adjectives. You want to consider off-site problems, disclose repairs, don't speculate. So for example, either you know that let's say there was a room addition, either you know it had permits or you don't know it had permits. You don't want to guess. They can, call the city and find out, but they're not speculating on it. Even if something doesn't bother you, like, it's an issue, but you've gotten used to it, it doesn't bother you, you still want to disclose it. And then, like I said, answer every question. And so the disclosure information advisory is an optional form. Now, I will say one of the things that they mentioned is on this, sometimes it says it's required or it's optional. That's from the state of California or the CAR perspective, but our brokers may require different things. So if it says optional here, that doesn't mean that your broker doesn't absolutely require it. So okay. Buyers have rights to cancel if they don't receive these forms. There's a number of different forms that will trigger the buyer's right to cancel. And so they can cancel if it's never been delivered or completed. And so completed means all three sections. So if they miss a section or they don't fully complete it, the buyer has the right to then cancel, even if they are outside of their typical cancellation rights. Now, this is talking about the TDS. And so section 1, 2, and 3, well, section 3 is in regards to the AVID. So that falls on us. As a listing agent, when you submit the TDS to the buyer, you also want to have your AVID attached, and your AVID should be done within the first 7 days, because on the RPA, unless a different date is written in there, the seller is agreeing to have all forms over to the buyer within 7 days by standard language. Also standard language on the contract is that they would have 17 days to review these forms, right? So there's 7 days to get them over to them, and then an additional 10 days for them to review them, equaling up 17 days. But they have that 17 days or 5 days later, whichever's later. So for example, if the seller doesn't give this to the buyer until day 16, now the buyer has an additional 5 days, and their inspection period no longer ends on day 17. And that goes for the TDS, for the AVID too, which is the agent visual inspection disclosure. So for example, if we were to send all of the seller documents over within the first 7 days, but as a seller's agent, we haven't done our AVID yet, and we don't get that over till 2 days before closing, the buyer can still cancel because they have 5 days to rescind, to cancel after seeing that. So if you don't get it, definitely be asking for it. There are some exemptions to who needs to fill out the TDS. So if it's an REO or foreclosure, probate, bank sale, government entity, or some trustee sales, not all trustees, they would be exempt from filling out the TDS. But if that's the case, there's another form that they would fill out instead. Now, some people think, okay, I don't have to fill out these forms if it's an as-is sale. If I flipped the property, then I don't have to fill it out. If I'm from out of state, or maybe I just don't know anything about the property, or I never occupied the property, the seller still has to disclose anything that they do know. Now, maybe they don't, maybe they never lived on it and they don't know anything. If that's the case, then that's a case, but then they have to disclose that they don't know anything and disclose anything that they do know. So there's no like exceptions other than the legal exemptions. Okay.
Lori, what form would they fill out if they don't know anything? When you said there's another form.
Well, if they're exempt, then there's a exempt seller disclosure.
Okay.
I think that's, exempt seller disclosure. But only if they're exempt for one of these reasons. But if you've never lived in the house and, maybe you bought it as a rental or whatever the case might be, or you're it's a corporate owner who doesn't know anything about the house, you would still fill out the TDS up here. And you would just mark the boxes like no, because again, it's saying, are you the seller aware of any of the following? I'm not aware. It doesn't mean it didn't happen. It just means I'm not aware of it. And then in the bottom or in the explanation, in that case, I would write never lived in the property, so not aware if any of these things happened. Now that's also up here at the top on the right here, it asks the seller is or is not occupying the property. So that gives you a clue. Okay, they never occupied, or they're not occupying the property, so maybe they don't know anything, or as much as someone, would know. But again, if you're just marking no because of that reason, I would definitely put in the explanations about never lived there, don't know this information. Makes sense?
Yeah. I guess I was looking at it as a personal thing with my grandparents' house. It wasn't a trust, and but there was obviously history. So the listing agent at the time gave me the TDS, but it wasn't a trust. So that's where the confusion was in my mind. But it's no big deal. I understand it now completely.
Well, and see the trustee sales, and I don't know a lot about this, so I don't really want to talk about it too much, but they're exempt unless, so there are cases where even if it's a trustee sale, it's not exempt from filling out the paperwork. So if that was the case where you weren't exempt, but you didn't have that knowledge, like I said, just fill it out, mark it, fill it out the best you can, and then just explain in the explanation. And that the reason for that is that then gives the buyer the opportunity to further investigate. If they know that the seller knows nothing about the house, then they know they're not getting any information about the history and that they should investigate further if that's a concern for them. And as agents, we should be pointing that out to them as well. Say, look, they never lived there. They're filling it out to the best of their knowledge, but they don't have full information. And is that a concern of yours? If so, how would you like to handle that? Okay, so this just talks about smoke alarms, carbon monoxide. I'm not going to go into that except for here. So the plumbing fixtures. So again, there is a law that every home in California has water conserving plumbing fixtures. Even though it's a law, there are a lot of homes that are out of compliance. And so when a seller sells their home, this disclosure is designed to tell them that this law exists, but it's not a point of sale requirement. So I can say, hey, this is the law. We do not have water conserving plumbing fixtures. We're out of compliance, but we're selling it to you that way. And you're just aware that you're buying a house that's out of compliance, right? The only exception to that is that there are some local areas that do have laws that, so they might require it to be retrofitted. And so that's where it's important for us to know what are the local requirements in our area. And is this something that we need to be concerned with or not concerned with as the agent? Okay, so this is the exempt seller disclosure. So if they're exempt from the TDS, then they would still fill out this form. And this is just highlighting about the plumbing fixtures, whether you know or don't know. Okay, visual inspection, the AVID. So by law, both agents are required to do a visual inspection. They are not required to fill out the AVID form, but they are required to do a visual inspection. Now, your broker might require you to fill out the AVID form. That would be, something different. They're required on all residential 1 to 4 dwelling units or a manufactured or mobile home. There's 2 ways to disclose your visual inspection information, and I'll show you those in just a minute. So this is the transfer disclosure statement. So this is what we were talking about earlier, and this is section 3. And so again, this form is not complete if section 3 isn't filled out, and section 3 falls on the agent while sections 1 and 2 fall on the seller. So these boxes give us a few different options. So 1, see attached AVID form. 2, agent notes no items for disclosure. Now, my broker does not want us to use box number 2. They want us to at least find something, even if it's just a crack in the driveway or the cement out front. And then agent notes the following items. Now here, you've got 4 lines to disclose any issues that you may have noted throughout the entire house. If you fill out the AVID, you'll see you've got 3 or 4 lines for every single room of the form. So definitely a lot more room to fill out information. I usually will put see attached AVID form, and then when under agent notes the following items, I usually put a statement that basically says that the agent always advises the buyer to do professional home inspections. And they said that that was okay to do. Okay, so that I talked about. Okay, so here's the differences, just the visual of the differences. So you can put out over here, put everything you know about the house on the 4 lines, or here you've got 3 or 4 lines for each specific room. On the AVID, what I usually put is if I don't see anything in the room, like if I don't notice anything in the bedroom, I'll put nothing noted. Or if there is no like 3rd bathroom, I'll put NA for not applicable. So they know that I've looked at, every room. Okay, and so what do we look for in the AVID? So we're looking for any material facts about the property that could affect its value or desirability. So there's a certain number of areas. So we're not required to, open cupboards, go like too far into it. We're not actual inspectors. That's what a home inspector would do. So we only have to require areas that are, reasonably and normally accessible. We do not have to inspect areas that are off-site. We are not pulling public records or permits or verifying anything like that. We're not looking at common areas of, condos or anything like that. We're not going up and looking at the roof or in the attic. We're not moving or looking behind furniture. We're not looking under the house or climbing up hillsides, looking under bushes, plants, fences. We're not operating the appliances. Definitely, we're not measuring the square footage. We're not determining if the property has mold, asbestos, or any other environmental hazards. If we see something that we think is mold, we're going to be descriptive about what it is, but we're not going to use the word mold because, we're not environmental professionals. Ernie, did you have a question or a statement? No?
No, I was just thinking when I do my Avid, I walk through and just kind of write down or make notes of what I see, and that's
Yep.
I mean, I even go the tile floor, two windows, double sided, vertical blinds, and then if something's broken, I'll add to it vertical blinds, two pieces missing or something like that. But,
Yeah. No, that's good. That's good.
yeah.
One of the things that we want to do, like you just said, if something's broken, is we want to identify any potential red flags. And so one of the things that they mentioned was popcorn ceilings. And I had never thought about writing popcorn ceilings on the Avid as a potential red flag, partly because I figure the buyer can see that there's popcorn ceilings, but that could indicate asbestos. And so we don't want to put popcorn ceilings could contain asbestos. We're just going to put it has popcorn ceilings, right? If there's peeling paint or anything like that. And so again, this form has to be done within 7 days of the client going under contract, unless a different number is filled out on the RPA shortening that. And like I said, from the seller side, not having this can trigger a cancellation right, but from the buyer's side, it does not. So if you are representing the buyer, you have more time to get it to them. And if you don't get it to them, that does not give the buyer any extra cancellation rights, only if you're the seller's agent. But you do want to make sure that you give this to them while they are still in their inspection period and before they've released their contingency, because you don't want them to release their inspection contingency and then see something on your Avid that makes them say, oh, I don't want this house, or, oh, I want to inspect this further, but now I can't. Okay. And on the form, so on the top of the form, it does highlight some of the things that agents are not expected to do. We're also not expected to analyze anything or determine like the cause or source of anything. Nor determine the cost of any possible repair. So I know a lot of times our clients will ask us, well, what will that cost? Or is that a big deal or whatever? And that's for them to research somewhere other than with us. So how do you do the visual? So first of all, you're looking for any material facts. Anything that a reasonably competent person would be able to identify. We're going to stick to the facts. So instead of saying there's mold, we're going to say there's green and black discoloration in bathroom number 1. Note I didn't say size of that, not a big spot of it or a little spot of it. We're just being factual on it. We're not speculating that it's mold. We're not saying it's toxic, it's easily cleaned, anything like that. We're not saying it's caused by a leak. Nothing like that. We are identifying red flags, which gives the buyer the chance to further investigate if they choose to. We do want to be specific, indicating the location of the facts. So there's a crack near the upper left corner in the wall facing the door, so that they can go in and know exactly. And then we're not going to, be like super specific measuring it or anything like that. One of the things that I like to do is I like to do my visual inspection when I'm representing the buyer while their home inspector is there. And usually they're there as well. And so even though I don't have it typed up and ready to give it to them to sign, I'm going to take a few minutes. I'm going to go over it. I'm going to walk my client through the house and say, okay, this is what you're going to see on the report when I give it to you. Here's the crack that I'm talking about. Here's the black spot that I'm talking about. That way they don't then feel like, oh, now I've got this report. I don't remember a black spot. Now I've got to go back and look at it. I'm just walking them through it. I'm also letting them know that anything I write down is not, it may or may not be important to them. I'm just visually writing down what I see without any, judgment on whether it's something they need to further investigate or not. Okay, so they want us to watch our language. So we're not going to say, there's no problems. We don't want to say it's remodeled all over. The example they give is it might be a remodeled house, but they didn't remodel this one bathroom. And when we put remodeled all over, that gives us liability because we're saying the entire house was remodeled. We don't want to say where repair work looks solid, because if they get in there and the repair work kind of falls apart, now we're kind of liable because we said it looked solid. We're not endorsing any seller statements. It appears as stated by seller. We're not doing anything that. And here it says you can include that general advisory urging professional inspection. So broker recommends that buyer conduct inspections, tests, surveys, or other studies with a professional of buyers choosing to investigate the property. You don't have to write that because that's already in other places, but I just like to write it. Okay. And again, within 7 days. Any question on that?
Hey, I got a question. There was a property, 2-story, and we're walking through the master bedroom or out of the ensuite into the master bedroom, and there was creaks in the floor.
Mm-hmm.
Did you disclose that or say anything about that?
I would.
Okay.
Yeah, I would. If I'm walking with my clients, with the buyer, I will, I will just say, hey, do you hear the creaks in the floor? And then I'll still put it in my report too.
Right.
Because for some buyers, that might be a huge concern. Other buyers, it might not be a concern at all.
Right.
Okay, so then we have the seller property questionnaire, the SPQ. And so this is going to be required anytime the TDS is required. This is a 4-page form. It's designed to jog the memory of the seller so they don't forget to disclose material facts. So it's going to ask them questions that are designed to make them think. A lot of agents will send this form, this one, the SPQ and the TDS, to the seller to fill out electronically. We definitely can have them fill it out electronically. What I like to do though is I like to print it out when I go to the listing appointment, and I like to leave these forms with them to fill out after I get the listing agreement signed. And I want them to walk into a room and really look around and say, okay, have we had anything fixed or repaired in here? And keep it with them for a couple of days so that if they remember something like, oh yeah, we did that, they can go back to the form and fill it out. And even if I need to give them a second form. So the first 10 questions are designed to fill in the gaps and tie up the loose ends of the seller's required disclosures, and then the rest ask for material fact disclosures. So there is the exempt seller disclosure, and that's if they're exempt from filling out the TDS. And the exempt form, the first 11 questions on the exempt form are exactly the same as they are on the SPQ. So as far as disclosures go, there are some that are mandated by judges. Legislative bodies have required some, the contract requires some, and then some are required for risk management purposes. This talks about NHD. So a seller technically doesn't have to provide the NHD report. They can fill that out themselves, but that would be silly because the NHD report, doesn't cost very much money. So they should do the NHD. The NHD report also triggers cancellation rights identical to the TDS. So again, you have to make sure you get that within those first 7 days, and they have 5 days to review it and can cancel within those 5 days, even if it's after their inspection period's over. Okay. The home hardening,
Lori,
and yes,
who orders the NHD?
Usually escrow does.
Okay.
It is something that can be ordered before you go under escrow. And on the RPA, there is a place to put, seller will or buyer will put, okay, NHD, who's paying for it, and what company do I want it from? Most of the NHD companies in my area will let you order it, and then if you don't end up using it, they don't make you pay for it. I don't know that all NHD companies are like that, but you could also counter that back. Hey, I already have it from, this company.
Yeah, that's.
But yeah, usually escrow.
A lot of agents use that as an added benefit to use you as your listing. They already ordered the NHD and have it at the listing presentation because they don't charge you until you use it.
Yeah.
Just
were you adding more, Ernie?
no, just yeah, just saying as a little added plus. They'll let you order it.
Yeah, definitely. And it's nice that they don't charge you if you don't actually end up using it. So
Yeah, and in our area too, if you're thinking about buying a property, you should get one right away anyway before you even to get an offer in because of the insurance, see if the property's insured. So
What does that mean, ordering it without using it?
So if it doesn't become the official NHD report of the transaction, so you can have it, you can, download it, print it, review it, and all of that. But from Snap NHD, but then when I get the contract, the buyer puts in that they want it from a different NHD company, and we end up not countering that out. Even though I've already looked at Snap NHDs, I don't have to pay for that because that wasn't the official one that we used when we went under contract.
Okay. And it's buyer's decision.
Well, it's negotiated. It's part of the negotiations of the contract. When the buyer submits the RPA, they'll either fill in a company name or they'll put seller's choice. And you can put in the agent notes, NHD by whatever. And then assuming the agent reads the agent notes, they can just put that in the contract as well. Okay, so the home hardening retrofits and defensible space. So in some of your areas, this is a huge deal. In my area, it's not a huge deal because we're not in a high or very high fire zone. But this is a big deal. Part of the reason that they require the home hardening retrofits is because in a fire, embers can fly up to a mile. And so that's part of the reason why wildfires can spread sometimes. There's I'm just going to go off my notes that I wrote from the day I was there. So there's the fire hardening defense. It's the FHDS form. Defensible space form. Okay. So it's a disclosure law, but it's not a retrofit law requirement. So the sellers are going to answer questions based on what's missing from the property. So basically the seller's saying it has been retrofitted or it has not been retrofitted. It's only a requirement for homes that are in the high or very high fire zone that were built before 2010. And that's because after 2010, homes are being required to be built with these things in place. And then we talk about defensible space. So defensible space is a zone that's around the house. Defensible space is a law that it always has to be maintained, but of course, sometimes we'll sell homes where the space has not been maintained. Some localities will require an inspection and some won't. It's not a point of sale requirement other than the fact that it always is supposed to be maintained. So what you can do is a buyer and seller can make an agreement. So buyer can say, okay, it's not been maintained. I will buy this house in the non-maintained condition, but I'm going to have it fixed within the next year. If an agreement isn't come to between buyer and seller on that, then it automatically defaults to the seller having to do it. Okay, so that's these next few slides here. There are maps. I think that the NHD reports, I don't know if they're required to disclose it now or if that's something that's coming soon, but the NHD reports will be disclosing it. But there are also maps, but you have to make sure that you're looking at the most up-to-date map. And then again, local law might be more strict than state law on it. And so you'll have to, make sure that you're aware of local law in addition to state law on that. And then here's a here's the form where it's again asking yes, no questions about the house. And then here's like the defensible space, and there's actually three. There's zone 1, zone 2, and zone 3. And then let's see. Okay. Any questions on what we've talked about so far? Okay, so then here we have the SBSA, which is the statewide buyer and seller advisory. This is a 14-page disclosure. They only sign on the very last page of this. It's highly recommended. My broker requires it, even though the state does not require it. It's really actually interesting to read if you haven't read it before, because it brings up some things that you might not normally think about, but it discloses like a whole ton of different things. One of the things that we talk about on disclosures is what we have to disclose as material facts. And so case law requires the disclosure of known facts that materially affect the value or desirability of the property. Do you guys, I mean, I think that that's pretty self-descriptive, but basically anything that might make a buyer say, no, I don't want to buy this house. And that can be subjective, every buyer is different. But basically we want to disclose anything that could be an issue. Sellers have a responsibility to disclose. Agents also have a responsibility to disclose, and those are independent of each other. So if a seller discloses it and we know about it, like we still need to disclose it too. They shared this one case with us. So it was an agent who was doing an open house, and at the open house it was a very affluent community, I don't know, like $1 million house. I'm not sure if it was $1 million house, but with views and all of that, right? One of the neighbors came in and they said, oh, I just thought you should know we're going to be doing a big construction project on our house, a big remodel, and we're going to add another story and it's going to affect the views. And they just told the agent that. So the seller didn't know that information. Nobody knew it but the agent. And the agent didn't tell anybody about that. And so the transaction, the seller found a buyer, they went under contract, they closed. And then when the new buyer was moving in, the neighbor came over and said, oh, I'm so glad that the construction and the building of the second story, didn't stop you from buying it. And the buyer's like, wait, what? Because this first time buyer had heard of it. So then buyer immediately said, I don't want to buy this house. I want the seller to give us our money back on it. Seller had no knowledge of it. Only the seller's agent had knowledge of it. It went to and the broker was held responsible because they had a duty to disclose, even though the seller had no knowledge, the agent had knowledge. So we want to make sure that, sometimes it's better when neighbors come over. It's like, I don't want to hear nothing, because then I don't have to disclose it, right? Here's another thing about being clear, complete, and candid. So they talked about another case where a buyer bought a house, and on the disclosure, so it was on a lake, and on part of the disclosures, it said that the water level fluctuates. Nice. Okay, so lake levels fluctuate, right? They go up, they go down, no big deal. So they bought the house, and then what they've realized is not does the water fluctuate, but at certain times of the year, the water level completely goes away. So your lake becomes no longer a lake. And so, of course, there was a lawsuit on that. And I don't know what the exact outcome was. It was not favorable to the seller. But you have to make sure that you're being clear. We can't be like too vague on what we're disclosing. We want to discuss reports with our buyer, and we want to recommend further inspections if there are red flags. We don't want to be in that position where we're telling them, this is a big thing, this is a little thing, I would care about it, I wouldn't care about it. We're just there to present the facts. The report says this. Is this something that you would like to further investigate? Okay, so on the SPQ, there's a couple of areas. Let's see, right here. It asks, is the seller aware of any reports, inspections, warranties, estimates, et cetera, et cetera? So there's no timeline on this. So it's not any estimates that you got done in the last year. It's like forever, right? And so if your client, like let's say your seller got an estimate for a new roof, they knew they were going to sell their house, but they thought maybe they'd put a new roof on. They got an estimate, it was too high, they didn't want to do it. So no, we're not going to do the roof, but we're going to now put it on the market. We have to disclose that we got an estimate for a new roof. And if we have a report for that, we have to give the buyer that report. And so we are required with no time limit to disclose those documents. Same thing with, let me see, material facts. So same thing with, any repairs that we've done, it goes back. And that's part of the reason I mentioned earlier that I like to print these forms out and leave them with my sellers so they have the opportunity to go through and be like, okay, let me just sit with these for a few days, see if I remember anything, because honestly, sometimes I can't remember what I did, 2 days ago, let alone what repair I might have done to my house 10 years ago, right? Okay, so standard language in the RPA says the seller has 7 days to get it to the buyer. The listing agent's avid has to go within those 7 days. We want to get everything signed by the buyer. The buyer signing the forms does not mean that they agree or accept to whatever's in the forms. All it means is that they've received a copy of the forms. And we definitely want to make sure that our buyers have signed that they've received a copy so nothing comes back and haunts us after the transaction closes. Okay, so one of the questions that it asks is, has there been the death of an occupant on the property? And so that there is a time limit. So we only have to mention if it happened within the last 3 years. The only time we don't mention that is if they died from AIDS or HIV. And even if they ask us that question, we don't answer it, which is kind of funny because agents know like that's an exemption. So if I say, well, somebody died, and they say, well, can you tell me how? And I say no, it kind of makes sense. Well, then they must have died of HIV or AIDS, right? Because that's the only exemption to sharing that someone had died on the property. But then there's stigmatized property. So even though we only have to share it within 3 years, if there was somebody that was, like it had been on the news or it's like known as the murder house or something like that, I would say you want to disclose that even though you're past your 3 years on that. And in my opinion, especially if it's not natural causes, even if it's beyond the 3 years, I think it should still be disclosed. But the law only requires 3 years. Then we have a disclosure about registered sex offenders. And so this goes back to, we have to disclose what we know. So as agents, we really don't want to be going on to the Megan's Law database, because if we go on there, we see something, we know something, we have to disclose it. And buyers get a notice that says, here's the website and you can go on and look at it. So if it's important to them, they can go on and look at it. There's an earthquake disclosure. One of the things I really like about the earthquake disclosure is it has this column that says don't know. And so anytime I've seen this filled out, a high number of these questions get answered with don't know because they ask some pretty specific questions that the average seller's not going to know. But again, if something's important to the buyer, this gives them the opportunity to go and look in a little bit more detail. Okay. I think that's all I really wanted to talk about. This is talking about there's federal tax withholding and state tax withholding. Ironically, it falls on the buyer to withhold that from the seller's proceeds, but that's something that escrow will take care of. And so we don't have to worry too much about it. Just make sure that escrow is taking care of it. One thing I'll say about HOA is that there is a form. It's an HOA advisory. It's called the BHAA form. And what that form will do is that will give them, the buyer, because if you've ever seen the HOA documents, like it could be 100 pages of stuff that the buyer gets, and the buyer can be overwhelmed and not know what to look at. And so this advisory says, okay, if it says like this, then it could mean that. And it's advising them that there might be lawsuits. Here we go. It's going to show them like in the minutes. You're going to look for, is there any future litigation or repairs or improvement or dues increase that, stand out when you're looking at the minutes? Are there any restrictions on renting? Noise restrictions like parking, drive your car into the parking lot. How many spaces are there? Where are they? Where are you allowed to park? Are there any pending lawsuits against the HOA? Because that's something that the homeowners are going to have to pay for, so it kind of gives them an idea of what to look for when they're looking in those documents. One other thing is that it states on here, legally authorized signer. So if you have a trust or a power of attorney or whatever, you have 3 days to deliver evidence of authority. So proof that you are an authorized signer. And again, that's something that that escrow will take care of. But we also want to be on top of that. One other thing that I wanted to mention, or I guess two things real quick. We talked about this a little bit earlier, right here on the RPA. So there's Q5 and Q6, and a lot of times we'll see these items being left blank. And these are in regards to government required point of sale inspections, reports, or corrective or remedial actions. Typically, it's common for the seller box to get marked, or they get left blank. There are some local communities that will have things that fall into here. So you want to make sure you're aware of what falls into here. But it's good to have a box marked rather than just leaving it blank. In fact, they definitely recommended that it not be left blank. The other thing that I wanted to say, going back to the NHD report. So the NHD report is a disclosure report. That's the natural hazards one. Oftentimes it gets signed in escrow, but it might not get signed in escrow until like the end. So maybe we're at day 25 and then escrow calls them in for signing and they sign it. That report is one of the ones that we were talking about earlier that triggers the cancellation right. So at that point, if the buyer signs it, they still have 5 days to cancel. So best practice would be to get that report, have your buyer sign it. They might re-sign it in escrow, and that's okay if they do. It takes away that cancellation right. So especially if you're representing the seller, you want to make sure that the buyer is signing that sooner than later. Okay, so we're at 12:31. I know we covered a lot, but is there any questions about anything before we end?
No, super informative. Thank you.
All right, you're welcome. Very good. Yeah, so just if you have questions about disclosures, like let us know. But other than that, thank you guys for attending. I appreciate you guys being here. I know we covered a lot, and disclosures aren't the most fun topic, but it's very important that we know this information because it helps us protect our clients and also helps us protect ourselves. With that, you guys have a great rest of your day and have a great rest of your week.